Okay. Good morning, and welcome to this webinar exploring the current legal landscape for Vermont's creative and nonprofit community with the Vermont Small Business Law Center, hosted by the Vermont Creative Network. We wish to acknowledge that in Vermont, we are within the unceded territory of the original inhabitants of Endakina, the Abenaki, and in the southwest portion, the Mohican people. Their traditional and ongoing relationships with the land call us to learn to be better caretakers of the land as well. We offer respect to their ancestors, their elders, and their relations, past, present, and emerging. With our mission at the Vermont Arts Council to cultivate and advance the arts and creativity throughout Vermont, we offer this land acknowledgement in part to honor and raise awareness about Indigenous artists and culture bearers working in our state today. We commit to supporting and amplifying their work. My name is Desmond Peoples, and I'm the Advocacy Communications Manager at the Vermont Arts Council. I'll invite you all to please put your name, organization, if you have one, and town in the chat so we can get a sense of who's in the room with us today. This webinar is being live captioned by Whitecoat Captioning. To view captions in the Zoom window, click on the Captions button at the bottom of your screen. Captions can also be viewed through your browser at the link in the chat. The Vermont Arts Council is proud to be the backbone organization for the Vermont Creative Network, a statewide coalition of nonprofits, businesses, and individuals all working to advance Vermont's creative sector. The Vermont Creative Network is also our state's leader in creative sector advocacy. We support policies and public funding that advance the creative sector, which in turn advances Vermont's overall economy and community well-being. And when we say creative sector, we're really talking about all of the industries, businesses, organizations, and individuals for whom creativity is at the heart of their work. We put creativity squarely at the intersection of economic development and community development, and we thank you all for being part of that. Today's the first in a three-part series of events this fall focused on advocacy. I hope you'll join us in person for the next events in the series. On November 17th, we'll be at Main Street Landing in Burlington, sharing the Creative Network's 2026 legislative priorities. And then on December 4th, we'll be at the Chandler Center for the Arts in Randolph, with a workshop encouraging creative sector folks to get involved in Vermont's political landscape at every level. More information on these upcoming events and how to register is at the link that Deirdre is sharing in the chat now. So we're all here today because the creative sector, like so many parts of society, is being impacted by the shifting landscape of federal policies. We know so many of you are trying to keep your work grounded through these times, so we've partnered with the Vermont Small Business Law Center to help Vermont's creative organizations understand and navigate the changing policy landscape. We hope you'll come away from today with some clarity as to how these changes affect your organization and some practical steps you can take now to sustain your work. We'll hear from our presenters and then we'll take questions. So please feel free to put your question in the chat during the presentation. I'll keep track of those and ask them to our presenters at the end. Also, a quick note that this webinar, including the Q&A section, is being recorded and will be made publicly available after today. Our presenters today are Jared Carter, Professor of Law at Vermont Law and Graduate School, Nicole Killoran, Professor of Law at Vermont Law and the Director of the Vermont Small Business Law Center and Clinic, and John Stockham, a student in his last year at Vermont Law and Graduate School and a student clinician at the Vermont Small Business Law Clinic. Jared, Nicole, John, thank you for sharing your expertise with us. Please take it away.
Will do. If you want to go on to the next slide. So I am Nicole Killoran. I'm delighted to be here today, guys. I'm going to walk us through the agenda real briefly. We have a number of overhead views of some of the issues that you're going to be dealing with. You can see the areas here. I'm not going to go into them in detail. I want to just note that we're going to cover substance first, and then we'll cover some practical steps that nonprofits can take to try to protect themselves. And then we'll step into the Q&A after that. So that's the agenda. If you want to go ahead, Jared. Can you go to the next slide? There you go. Nope, one back. Sorry. So Vermont Small Business Law Center, just wanted to note here, we are providing free access to legal services and legal information for the state of Vermont's businesses and nonprofits. We work with for-profits and nonprofits both. You can see our mission here. Our purpose is to educate and to prepare nonprofits and businesses to be successful. We offer both individual educational consultations with people who are running nonprofits or who own a for-profit business. We offer group events like this. We also offer a free referral network, a free referral with 10 hours of free services that an attorney provides to any business who contacts us. If you go through our educational program, and then we can place you with an attorney to get you those free hours, no cost to the business. That is what we do. We also want to make sure that the business community, whether you're a for-profit or a nonprofit, is aware of current legal issues, and that's part of why we're here today. We're trying to prepare everybody to be able to look into the future and anticipate what they need to know that they may not know already. Go ahead to the next one, Jared, please. So we are, frankly, quite occupied with the nonprofits in Vermont. We have a lot of them. 6.3 public charities per thousand residents, highest concentration, one of the nation's highest concentrations. So we got a lot of them. We have some funding from the arts organizations. That's a vital entry point, obviously. Today, we want to talk about how these things intersect. Where does the federal picture overlay with the state picture? How do those things intersect? How do they interact? And what should a tiny little nonprofit doing arts work in Vermont know about this big picture that they're facing and all of the rumors that are swirling this year? So I'm going to hand it from there over to Jared. He's our expert.
Great. Thanks, Nicole and Desmond and Deidre and John, and welcome everybody. So my name is Jared Carter, and I'm really happy to be here. And the content I want to share, I've sort of divided, as you'll see, into the good news and the bad news, and then back to the good news. Because I think even if we're feeling concerned and confused, there is good news. And I think we should emphasize that. And I think if we understand the landscape we're operating in, we can actually really flourish and thrive. And I think there's a moment and a space for creativity within all of this consternation and confusion. And so I'm really excited to be here. And I would just add, before I start with the good news, and as you'll see in a minute, the courts, the U.S. Supreme Court, which is our talisman in the legal space, agrees with what I'm about to say, I hope and think, and that is the arts. And I'm a First Amendment lawyer. I guess I should have said that, but I'm a First Amendment lawyer, so my area of expertise is First Amendment rights. And speech and expression are core to that. And in my view, the arts in particular, and this is why I'm so excited to be here, is really at the forefront of that expression, that speech, that quite frankly is critical and has always been critical to progress in the United States. And so I think it's only fitting, and I was really thrilled to hear Desmond share that this is part of an advocacy process that you guys are talking about and thinking about, because artists and artistic professionals and lawyers and advocates have walked hand in hand to try to move these things forward, and you all are really at the forefront, which can be scary and intimidating, but also really empowering and provide us with real opportunities to make a difference, even in these sort of moments when it feels uncertain. And so I guess I want to start off. The sun just poked back out here in Burlington, where I am, and it's sort of starting to feel like a really nice day. But I want to reflect on the reality that I'm sure many of us are feeling, that it's been a heck of not just a past 1 year or 6 months, but it's been a heck of a past 5 or 8 years. If you kind of take a moment to just reflect on what we've all experienced, whether it was COVID, whether it was various political administrations, various events in our own lives as a relation to all of those, it's only natural that I think we feel confused and concerned and hesitant. And I'd love to just, by a show of hands, if you guys know how to raise your hand on Zoom, how many people are sort of feeling that? And maybe that's part of the reason that you're here today, is to come together with a group of like-minded folks to think about this stuff and talk about this stuff. I certainly feel that way, and I think it's totally normal. What I want to share, though, and this slide starts off with it, is that in my view, despite all of this, you want to know what I think, and this is as a lawyer and a First Amendment lawyer in particular, is that the rule of law is alive and well, and it's going to be okay. And the reason I believe isn't because I don't see the reality of what's happening, and I think this is regardless of one's political viewpoint, right? The reality of some of these issues that we're dealing with. But what I see is that the rule of law, as I see it, is not something that's written down on a piece of paper. It's not in the Constitution. It's not in a law. It's not in a statute. It's not in a regulation. The rule of law is this idea that all of us collectively believe that when it comes to our rights and responsibilities in the society and culture that we live in, that whether we agree or disagree, we believe in the process and we believe that the law should apply to all. And sure, we might see places where we don't think that's happening. But I think as long as we hold on to that fundamental belief, then we're going to win some, we're going to lose some. There's going to be 2 steps forward and 1 step back. And in an advocacy space, it's important to understand that. But we're ultimately going to be okay. And I think we see that even under these stressful times. And this case I like to start with, it's a well-known constitutional First Amendment case that we teach in law school, but I think it's emblematic of what we're talking about here. And this is why I still believe in this principle of the rule of law, and that if we all hold to it, it's going to be okay. And I think it's echoed in this idea that this quote shares, and this is a famous case, Rock Against Racism from the 1980s. There's others, but right, this really I think encapsulates this idea that art as expression, as a form of communication, as a form of interacting with each other, is fundamentally protected by the First Amendment, right? And you want to know what that means? What it means is that even in the face of headwinds, in the face of difficulties, there is this sort of guide star, and this is what fires me up about the First Amendment. There is this sort of guide star that is going to protect that light, that kernel that's so critical, I think, in our society and moving it forward. It means that no matter what the law is, what policy the federal government puts forth, or the state government, or a local government, or whoever, right? If it burdens that freedom of expression and that freedom of artistic expression in particular, it's going to be subject to the highest level of scrutiny, right? They aren't just going to get away with it, right? That's what that means. In law school, we talk about judicial scrutiny, and we talk about something called strict scrutiny, right? And what that means is that when a law or policy burdens that fundamental right, in this case of artistic expression, free speech, it's only going to be constitutional if it's a narrowly tailored law and it's meeting a compelling government interest. In other words, it's really hard for the government to meet that burden. And so far, the courts are upholding that principle. And so that's why I feel and wanted to start with this concept of not only the First Amendment as an underpinning of all that we're doing, but this idea that the rule of law is there to support us along the way. And in fact, as I think you'll see in a few moments, it's actually doing that, even if it doesn't all feel like it. So that's the good news. Yes, there is some, let's call it moments of trepidation, maybe to put it lightly, but there is some not so good news, right? In a democratic society, there's 2 steps forward, 1 step back. Sometimes 2 steps back, 1 step forward, right? It's not linear. So there is some not so good news. And I think much of what we're going to talk about today is thinking about what that bad news is and how can we deal with it, right? Underneath this principle that the rule of law survives, right? And so the bad news, I think, in some ways stems from another part of the Constitution. So yes, the U.S. Constitution can in some ways protect us, but in other ways maybe harm us. And I think this is an instance of that happening, right? So the other part of the Constitution that's, I think, most relevant here, and I always like to start with the Constitution in a legal context because it really is fundamental, is Article 1, Section 8. Right? That's the part of the Constitution, and there's some other laws that do this too, that gives the federal government the power and the discretion to decide how to spend federal money or where to give tax benefits. So you might say, well, what the heck does that have to do with any of this? Right? Well, what it has to do with any of this is that it's this constitutional power, the power of the purse, if you will, right? Which makes some sense, right? The federal government should be able to decide through the democratic process how to spend the money that it gets from taxes or debt. And yet at the same time, what we've seen is a flurry of executive orders targeting nonprofit organizations and, quite frankly, their ability to express themselves in the way that they want, right? And it's happening either directly, where the government says you can't say those words, or indirectly, where perhaps there's threats of taking away one's 501c3 nonprofit status. They aren't necessarily saying you can't say those words, but they're saying if you do this or say that, you're going to lose some privilege. And so that's, I think, where this tension is between that fundamental First Amendment right for individual artists, for individual arts nonprofits, for nonprofits writ large. Yes, we have the right to say and think and express what we want. On the other hand, the government does have some ability to regulate and control how it spends money and how it gives tax benefits. So there's this fundamental tension between those two principles. So what are some of those executive orders that I highlighted a moment ago that we're seeing? And I'm sure many of you have probably heard about some of these if you're following this. But the most relevant here came down early in the year. Some of the early actions that the administration took to introduce really new requirements for grant recipients, right? In the arts and other areas, obviously, we depend on often grant funding to do the things that we're doing. And so this is highly problematic, because what the executive orders did was put conditions on what applicants for those grants must certify that they don't do. And the two main ones that I want to highlight here are they required that applicants demonstrate that they will not advance gender ideology or operate illegal DEI programs. Okay. And so at first blush, what I would say to this as a First Amendment lawyer is, well, wait a minute, they're telling people what they can and can't say, right? Or can and can't promote, right? Isn't that a violation of their First Amendment rights? And as we'll see in a minute, I think the answer is, and has been, a resounding yes, it is. Doesn't mean that the administration won't try to do these things, but the rule of law has prevailed, as I think we'll see. But that's what these particular executive orders did, and they're highly problematic, not just from a First Amendment perspective, but because they're pretty vague and ambiguous, and that creates a lot of uncertainty among applicants, among nonprofits who have depended on grant funding over the years from the government in some instances, to know what they can and can't do, or what should they say and not say. And I sort of have this picture, and I don't know if it's true or not, is there's like a few people in the White House who are Googling, like Vermont Arts Associations and DEI to see if it pops up on their websites. And there may be some truth to that. But I think that's the concern, is like, what do these things mean? And how does it create risk with respect to funding that's so important to a thriving arts community in Vermont and across the country? So what have been the responses from some of the large organizations that do this funding, the NEA and the NEH? A couple of things. And again, maybe folks have some level of familiarity with this, but I think it's important to understand the lay of the landscape before we talk about solutions, right? Where are we now? So there's been the discontinuation of some programs, for example, the Challenge America program, and there's direct impact from these things, right? Small grant programs, which particularly for Vermont applicants and organizations in rural areas was really, really important, right? $10,000 is a lot, right, for a lot of these individuals and organizations. They also instituted compliance and screening programs across all of their areas of grant making and beyond, right? And again, this is where I picture the person is Googling these words and seeing if the organization has any association with them, right? But these screening and compliance programs that now you have to meet. The NEH took a similar but somewhat distinct approach with a renewed focus on, quote, merit-based awards and eliminating several diversity, equity, inclusion related offices throughout the internal organization. So it's a reorienting of how the federal government is interacting with applicants, with grantees, right? And the upshot, I think, is fair to say this creates all sorts of complexities for organizations, difficult conversations. I mean, I'm a member of several boards here in Vermont, and we're having, and as I'm sure many of you are, we're having real conversations about how do we balance our organizational mission around, say, inclusivity with, the federal eligibility requirements for grants or for concerns that it's going to impact our 501(c)(3) status. These are important and legitimate concerns, but they sap energy from organizations. So yeah, there's the bottom line, right? You can't get the $10,000 grant, but there's also the sort of less tangible impacts of the time and energy that organizations have to put into dealing with these. And I think those can't go without mentioning. And these aren't all of the changes, but I think these are the most perhaps relevant here with these two organizations. Let's come back to some good news, right? We can alternate. We'll ping pong back and forth a little bit. Hopefully, we end up in a space where we're all feeling at least somewhat optimistic, even in these uncertain times. But the reality is that despite these, in my view, directives that clearly implicate constitutional and First Amendment rights, organizations across the country have learned that there are multiple avenues in which we can push back, which is why I was so excited to hear Desmond talk about advocacy. Because one of the things that we can do, and one of the things that art is so powerful at doing, is advocacy. Advocacy, I teach an advocacy class at Vermont Law School, and one of the things I talk to my students about is like good advocacy is artistic, right? And I don't mean necessarily like drawing or painting or music, but there's an art to coming up with an argument and a strategy, and it's jazz. And so I'm thrilled to see that you all are thinking about it in that lens and talking about advocacy, as it's really quite fun, even if it has real world implications. So I am optimistic. But here's what organizations have been doing, and I'm going to try not to bore everyone with legalese. And I'll explain each of these in turn. But one of the things that organizations have been suing, often with the ACLU or other organizations across the country, the administration, and bringing what we call Administrative Procedures Act claims. And I'll talk a little bit more about those in a minute. They've also brought constitutional claims, right? So the First Amendment, free speech, free expression claims against these regulations, these executive order, these restrictions. And then organizations are getting smart. And sort of the second half of this presentation will be, all right, maybe we aren't all going to go out and sue, although that can be fun. And I can certainly put you in touch with lots of lawyers that do this work if you're interested in talking to them. But maybe we aren't going to go out and sue, but how can we protect ourselves, right? What sort of risk mitigation steps can we take here? And I think all those are good news because they are concrete, actionable things that we can do in this moment, and have been working, right? So let's break each of them down, right? Administrative law. God, that sounds really wonky, and you know what? It kind of is. But basically, what it boils down to is in the United States, we've got three branches of government. We've got the executive administrative branch, right? The Department of Environmental Protection, right? The Department of Education, although I guess that one doesn't exist anymore, right? Or who knows, right? These are the administrative agencies. We have Congress and we have the judiciary, right? So we all know Congress's job is to pass the law, right? That's how it works. Congress passes the laws. The executive or administrative state carries them out, right? It puts meat on the bones. It puts them into effect. And so in reality, even though we don't necessarily see it, organizations, individuals interact more with the administrative regulations or administrative interpretations of the law than you do with the law itself, right? If you look around the room you're in right now, there's probably all sorts of safety regulations that are mandating that you have a fire extinguisher in the room, or you have a fire alarm, or you have sprinklers, or that the electrical outlets meet some regulatory standard, right? The regulations are really what impact us. Here's the thing, because Congress passes the law, the president, whoever the president is, whether it's Joe Biden, Donald Trump, Barack Obama, Kamala Harris, it doesn't matter, right? President can't just come up with regulations that they like and say, let's do this. And so, in fact, they have to comply with something called the Administrative Procedures Act, which generally requires them to go through this process to make sure that the regulations are, number one, consistent with what the law says they're supposed to be, and number two, not irrational, right? And if either of those things aren't met, the regulation can get tossed out. And so what we're seeing organizations do successfully is saying, hey, wait a minute, NEA or NEH or other government agencies, what you're doing is not consistent with what the law says. And by the way, it's arbitrary and capricious. It's irrational, right? And they're successful, right? They're successful, right? Normally, the way this process plays out is the government can propose a new rule or new way of deciding how to issue grants. There's an opportunity for the public to comment on those, and then the agency comes up with a decision based on that public comment, right? What the executive is doing here is just issuing executive orders and trying to bypass all of that. Well, guess what? In many instances, they can't do that, and organizations that are pushing back are being successful, right? So I hope that wasn't too wonky, but that's what the Administrative Procedures Law and Administrative Procedures Act and that strategy is really all about. And I want to highlight this key precedent that I think implicates both that APA component, but also the First Amendment component. So there's a case recently out of Rhode Island, and it was brought by the Rhode Island Latino Arts Organization against the NEA. And it was a situation where the NEA was essentially, applying those executive orders and saying, artists, you guys can't be supporting artists that do this sort of work, or artists that are that type of person, right? They were enforcing the rule in that way, right? Or that you couldn't express these ideas. And at bottom, what that really was this thing called viewpoint discrimination, right? Where these organizations were being denied funding under the executive order based on what they were saying and what their viewpoints were, right? And again, this idea of expression is fundamental, obviously, to the arts community. And we'll talk more about viewpoint discrimination in a second, but the court said no. That is unconstitutional under the First Amendment, right? Because it violates the requirement that government restrictions on speech must be neutral, right? In other words, the government can't say, if you say this viewpoint, artist, right, your painting expresses this viewpoint, you're good. If it expresses that viewpoint, no funding, right? That's called viewpoint discrimination, entirely unconstitutional, presumptively unconstitutional. Court said that, and the court also said that under the Administrative Procedures Act, the NEA provided literally zero explanation of what promote gender ideology meant to the applied project. In other words, it was arbitrary and capricious, right? So it was a powerful ruling, and I think one that we can look to and rely on when we think about, where are our rights, what are our options, what are the avenues?
Jared, this was a SCOTUS case?
No, this wasn't a SCOTUS case. No, this is still. In September, the federal district court ruled this way. I don't know offhand whether it was appealed or not, but it was a case brought by the ACLU. And there's been others. I have a slide in a minute that highlights the statistics that John was able to pull up. Actually, thank you, John. The statistics on these cases, which have been very much in our favor. So again, I think a moment of optimism. All right, so that's the administrative procedures sort of side of things. What about this spending clause, that Article 1, Section 8 that I mentioned a little while ago? It says the federal government has the power of the purse, and it can put conditions on federal funds. What do we do with that? Well, it's true. It can, but again, it can't do it in an arbitrary way, right? Even when it comes to how the government spends its money, it's got to do it in a way that is unambiguous, right? It can't say we aren't going to fund gender ideology in part because who knows what that means, right? It's an ambiguous term, right? They've also said that funding decisions must relate directly to whatever the program's objectives are. Um, and if they don't, then that's going to be likely unconstitutional. And then finally, funding decisions can't be coercive, right? So what they can't do, and this intersects with the First Amendment as well, what they can't do is say, hey, if you agree to talk about and publish and write and do art this way, we'll fund you. If you don't, we won't, right? It can't be coercive. It's got to be neutral. It's got to be fair. And I think that's really what's fundamentally underlies this. And I think the arguments that we're seeing, and again, they're successful, is that these executive orders, like the ones I highlighted a moment ago, really impose these vague ideological concepts, and therefore go beyond what the spending clause allows in terms of regulating how the government spends its money, right? It's not just saying, well, we will spend our money on X or Y. No, what they're saying is we'll spend our money on X if X agrees with our viewpoint of the world, right? So the government can sort of decide we fund this widget or that widget, but not this. What's something other than a widget? I was going to say gidget, but I don't think that's right.
This
Yeah,
program.
right. We can fund this and that, but they can't do it based on these vague ideological
Right.
concepts, and that's what the courts have been saying, right? And in fact, as the last point here says, Vermont and other states have gotten involved themselves through their attorney generals in litigating these issues as well, because in a lot of instances, the federal government is saying to the states, "Hey, state, you're not going to get this funding or this block funding or whatever it is unless you agree to, not talk about DEI or gender ideology or whatever the vague ideological restraints are," and they've seen success as well. So again, the rule of law, even if it feels confusing and overwhelming right now, is largely holding up. And I know this is a lot, and we're going to have time for questions at the end. Normally, I would stop at each slide and say, does anybody have any questions? But we'll have time for questions at the end. So I want to just hit on, we talked about the Administrative Procedures Act and how that's worked as a check on this power. Now I want to talk about the constitutional limits on the ability of the president, largely the administrative state, to do this. And I think there's really three constitutional buckets that I would point to and that have seen success in challenging these, particularly these spending decisions, these executive orders around spending decisions that are coming from Washington. First one is First Amendment. That's sort of my wheelhouse, so I'll emphasize that the most. The second is the Fifth Amendment, right, which protects us against irrational decisions of government, right? We're all entitled to some level of due process, even within funding decisions. And then that separation of powers and executive overreach, which I've touched a little bit on already, but we'll highlight some more. So those are really the three areas of law that I think have the most to do with pushing back against and protecting ourselves from these decisions of the federal government. So the first space is the First Amendment. And the First Amendment's a beautiful thing. It really, I think, is fundamental to our ability to function as a democracy because it protects. I think without the First Amendment, I always say the rest of the rights that we have are in some ways meaningless, right? The First Amendment's what protects our ability to talk, to share, to debate. And there's a lot of different theories about why the First Amendment exists. I think one of the reasons that often gets overlooked is the First Amendment acts, in my view, largely as a safety valve, because it allows people to speak their mind, right, or to produce art about what's in their minds. And the alternative is, and you see in some societies where this doesn't exist, a move towards violence. Right. So the fact that we can get these things off our chest through speaking, through performing, through doing this, right? That's that safety valve. And I think it's often overlooked as one of the most fundamentally important pieces of the First Amendment. But here's what we know about the First Amendment. The First Amendment prohibits the government from making laws or passing regulations or issuing executive orders that either are viewpoint or content-based discrimination. Okay. And I'll take that one first. So When the government or the president passes or issues an executive order that says we will support organizations or individuals that have one viewpoint but not the other, that's quintessential viewpoint discrimination, right? If the government says we're gonna give grants to groups that identify as Democrat, and we're not going to give them that identify as Republican, or vice versa, or groups that discuss a particular issue in a certain way or have a particular political viewpoint, that's viewpoint discrimination, and those are per se unconstitutional, really problematic laws, and the courts have said can't do it almost invariably. Content discrimination is sort of similar, but another area where basically the government is picking and choosing winners based on what the speech says, right? What type of speech it is. So, maybe that when the government says, well, we'll allow art that it uses religious content but not political content, right? Or we'll allow speech that has this sort of content, not the other. The government said you can't do that, right? Or the courts have said you can't do that, right? Disfavoring or suppressing certain viewpoints over the other. And this was front and center in that Rhode Island case that I talked about a minute ago, and was really part of the reason the court said no. The other sort of flip side of this First Amendment principle of viewpoint discrimination or content discrimination is First Amendment retaliation. And that's essentially what it sounds, right? Where the government punishes an individual or an organization because of its speech, right? So you publish a book critical of the criminal justice system, right? And you get fired from your job, right? Or you produce some piece of art and you lose your funding, right? So you've exercised something that's clearly protected by the First Amendment, and the government retaliates against you. And same way with viewpoint and content discrimination, courts have said can't do it. It's unconstitutional under the First Amendment. So while the government has the right to control the purse to a certain extent, once it crosses that line into retaliating or picking winners and losers based on viewpoint, courts have said no. All right, so Fifth Amendment, skipping ahead 4 amendments in the Bill of Rights. The Fifth Amendment really looks at due process and this concept of vagueness, right? And due process, as I'm sure you're aware, is this idea that before either taking away a right or a privilege or funding, the government has to give you a process. We call it both procedural due process and substantive due process. But basically, we're talking about a process, the opportunity to be heard, right? And by taking that ability away, the government violates that fundamental principle of due process under the Fifth Amendment, right? And so when they use terms like illegal DUI or gender ideology, and there's no sort of standard where they've explained what that means, it means you have no ability to use the process to protect your funding or protect your rights. And this idea of vagueness is sort of similar, right? How do we know what we're supposed to do if they don't explain what these things mean? Right? I don't know what illegal DEI is. I don't know what they mean by gender ideology. So how am I supposed to, as the executive director of an arts nonprofit or an artist, know whether I'm running afoul of that or not? To the extent we care if we run afoul of things like that is a fair question. But if you can't identify what's legal and what's not, or what's fundable and what's not, and they're taking away something that you have an interest in, like a grant, then the law is void for vagueness, right? And it's this Fifth Amendment principle of due process, and that we all should be able to have notice of what's allowed and what isn't. Otherwise, that due process right is violated. And this is another area where organizations and individuals have been pushing back successfully. And then finally, the separation of powers, right? Executive overreach. As I talked about earlier, Congress passes the law. The executive or the administrative state has the job of carrying that out, but they can't do something that runs counter to what Congress allows. And I'll give you an example of a case that just got argued yesterday that was in the news. It's not necessarily arts related, but I think it illustrates this point. Maybe you all have heard about back in April, I think it was, we had National Liberation Day where we got those really high tariffs. Um, and whether you agree with the tariffs or not doesn't really matter. But that case was heard yesterday at the U.S. Supreme Court, and what the fundamental argument was about was, does the president have the authority to, under the law, under the IEEP, which is an Emergency Powers Act, under that law, does the president have the authority to unilaterally issue these tariffs? And the court's looking at the law and saying, does it give him that power or not? Because without that power in the statute, it's illegal, right? And so that's what we're talking about here. Do the statutes that exist give the president the authority to issue these executive orders at all? And if they don't, then they're illegal, right? Because of this principle of the separation of powers. And again, organizations are seeing success using that as well. How much success? A lot of success. I saw this stat, right, where we've got 230 active lawsuits challenging these executive actions, and approximately 190 of them have resulted in injunctions. I wish I could bat that in my litigation practice. That's unbelievable. And it just goes to show the power of the law. And just to be clear, what we mean by a preliminary injunction is somebody sued, like the Rhode Island Latinx Arts Organization sued, and they asked the court to essentially say that executive order is blocked, right? That's what we mean by an injunction. And out of the 230 active lawsuits, 190 of those have resulted in that injunction, saying that that law is illegal, unconstitutional, violates the Fifth Amendment, the First Amendment, the Administrative Procedures Act, and it can't go into effect. Now, some of those are going to go through appeals, and we won't really know the lay of the land in some of these spaces until and if and when the U.S. Supreme Court decides them. But the fact that we've got judges across the political spectrum appointed by Republican and Democratic presidents blocking these executive orders, I think shows that that power of law, the rule of law, is still protecting us in many of these instances. And I think we can take heart in that. And Vermont's taken I think a powerful step itself. It's joined many of these multi-state lawsuits. So oftentimes states who believe that their citizens are being having their rights infringed upon in some way will bring cases where it's the entire state, right? And ultimately, it's often multiple states litigating on some of these principles, and we've seen success there, right? So I think the upshot here is that the consensus with respect to litigation is that it's working. I suppose you could say it's unfortunate that these things have to come to litigation, but it's the way the system is set up, and as long as it's providing that important check on government overreach, then I think this is why I believe we're going to be okay, right?
That's why the rule of law exists.
That's why the rule of law exists.
We have evidence.
Exactly, right? The fact that we're here talking about these things, I think, in this moment is it's community coming together to support each other, to think about these things, to talk about these things. We don't have all the answers as lawyers and law professors and law students, of course. But that's where I come back to like advocacy and thinking about this stuff is there's an art to it all. But equipping yourself with those tools and with this knowledge is, I think, an important first step. So
Yes.
With that, I'll turn it back over to Nicole.
I'm going to transition us to some practical steps that we can take now. So we've got a lot of information that Jared's been delivering, and thank you, Jared. I think that was a very clear explanation of some of these really complicated constitutional concepts that really govern a lot of what we do daily and what you guys do as arts nonprofits. What are you going to do about all of this? My suggestion is to inform yourself, to educate yourself. We provide educational services at the Vermont Small Business Law Center. We're certainly happy to provide that for you. But it may be necessary, especially if you are running an arts nonprofit, if you feel like your funding is being threatened, it may be necessary to contact counsel, to speak with an attorney, and to establish that relationship as early as possible. We can help with that. Again, we have a referral program. If you want, you can come to us. We can get you free 10 hours and connect you to somebody. But having an attorney, period, for a small nonprofit is critical. They help you identify what you need to be aware of. They help you understand what you need to understand, and they can help you spot the things you may not see without legal training. That's part of why do what we do. We can see into someone's circumstances and anticipate what they need. There are options to find one. I've mentioned our program. There's also a lawyer referral service with the Vermont Bar Association. If you wanted, you can call them. They will find an attorney. You pay them $25 for half an hour of advice, and they might help you. There's also word of mouth. Finding counsel, especially if there's a threat to one's funding, is going to be really important, and establishing that relationship to protect the future steps is going to be important. I'm mentioning this because there's an upcoming organization that we're very excited about called the Vermont Nonprofit Legal Hub. They're currently trying to fund themselves and get started up. They will be providing services directly to nonprofits. We covered for-profits and nonprofits. The Nonprofit Legal Hub will only support nonprofits. So hopefully they'll be up and running pretty soon, and we'll be helping them do it. I'm going to hand it over to John to go over some of the basic risk mitigation steps. And I think Jared's going to pick it up from there too.
Hello,
Go ahead.
everyone. My name is John Stockham. I'm a student clinician with the Small Business Law Clinic. I wanted to go over some substantive steps that you can take as a nonprofit, as an arts nonprofit specifically. And I really feel for all of you and have great love for what you do. I was a part of an arts nonprofit that I helped start. I wasn't the founder, but I was great friends with him, and I was really involved in that discussion. I was their grant writer, and I know how scrappy and how difficult and challenging and how much work it puts on everyone to make these organizations really form and perform. And so I commend all of you for that. As far as what I think is very important for you to understand is a lot of organizations, and I've noticed this in Vermont specifically, they form without specific legal help. And when I say that, in a sense, like a lot of these nonprofits are not getting direct guidance on what they should, what they shouldn't do, how they should do things. For instance, people may turn to like LegalZoom in order to get things off the ground, or you might use, internet. Web browser searches or AI or even advice from other groups, all still very helpful because those are sources of that will help inform you. And it's very common, but it does often leave gaps that you really may be unaware of. So I think just to kind of hone in on what Nicole is conveying to you is that having legal representation, I know that can be daunting because of the financial aspect of it. There are resources for you, and Small Business Law Clinic, we have some resources, and if it's something specifically that we can't offer you or help you with, we're not just going to drop you. Like we will get you connected with someone who can. So please keep that in mind. There are sources for you here. And why you will need those is because once you get connected with a lawyer, they can review your organization structure, they can review your filings, they can confirm that you are in compliance with both Vermont regulations and with the federal regulations if you are using federal dollars. And there's a lot of inconsistency and maybe less so with arts organizations, but it really depends where your funds are coming from. But if you're getting the NEH funds, the National Endowment for Humanities, because you have an academic or an educational aspect to your organization that's still also doing work that involves funds from the National Endowment for the Arts. Those two sub-organizations of the federal government or agencies aren't necessarily giving the same requirements or providing the same information for compliance. And it can be, and it really comes down to that legal interpretation, and you really need to have representation to look at that and make sure that what you're doing, what you're saying, what you're documenting meets those standards. And this is more of a mitigative measure. Obviously, as Jared mentioned earlier, you are more than welcome to, with the advice of your attorney, I guess, engage in lawsuits. But I would shy away from that personally just because I don't have the money to blow on that. But just something to consider, taking preemptive steps will really help you. You really also need to take a look at your organization's mission, your organization's overall messaging, and also reassess your purpose. You wrote a purpose for your organization when you became a nonprofit. That is what the IRS is relying on and to classify you. And if that purpose is not broadly written, the scope of everything you're doing could be in question, and you need to make sure that that's not happening for you. And it does happen. And it does fall through the cracks with a lot of organizations because there's not really someone looking over your head, making sure that you're, not, maybe perhaps engaging with other community centers or something of that nature, not educating people because it's just, it's a good natured task. But if it falls outside your purpose, if your mission, your purpose start de-aligning, it opens up an avenue for somebody at an agency from the federal government to review you. And that review process, even if you've done nothing wrong, it can be costly. It can drain you. It's just you want to not get involved in that. And so really make sure that you're speaking with an attorney about that. Keep strong records. This is another reiterative issue, not just here in Vermont, like again with my own prior organization. Um, I think we all underestimate how much we should be documenting the things that we do and aligning them with our purpose and with our mission. Um, that is great evidence and great habit evidence to help you establish compliance. Keeping concise records is very important. Uh, and on that discussion of records, consider what you're documenting in your minutes. And this is something I've personally was just interested in academically, and I'm in a nonprofits class, and I love it's just such a fantastic subject area in law. Um, and and because records keeping is so important, what should be included in those minutes? And you really do want to speak with a lawyer, number one, but just and for just more of an academic perspective of what you should be keeping, have you not spoken with a lawyer at this time? Really very concise, very narrow, day, time, who's in attendance, who's required to be there. That should be clearly documented. What are you voting on? So why was this meeting convened? What task are you addressing? What some nonprofits, overzealous minute takers may do is like line item conversations. John said X, Y, and Z, and John thinks this, and John would like that is not pertinent to your organization's purpose and mission, and it is not something you should be putting in your minutes unless John proposed this. That would be appropriate, but and you really need to be very specific about the relevance of what you're including because those minutes are really just again to ensure you're in compliance. That's all they're there for. So, did the board make a decision that was appropriate? Are they following their guidelines? Are they meeting all these kind of requisite things that the IRS provides in its regulations? That's what those minutes are for. They're not
Just want to
to.
note here too, John, sorry, that they're
Yep.
public. Those are disclosed to the public. So those become record that the government can use in some sort of a targeted action.
Yeah. Yeah. And don't expose your board members also to public scrutiny where it's unnecessary by writing down their personal opinions and perspectives. It's not good practice. Um, and this is not something you should be expecting the minutes taker to know. Really, I think separate even just from like getting legal advice, in regards of your status in your nonprofit, you should be discussing with your board, are we doing training? Have we all agreed on what the rules are? Have we established a procedure for what we're going to do, for instance, if an investigation starts, right? You need to be able to manage your inquiries efficiently. And I've never been audited, thank God. But I imagine like even the IRS just doing an audit on regular taxes is a very dreadful experience for people. And they're just like, oh my God, like what did I do? It could be random. You may be subject to a random audit. So take a minute, process like, objectively what's going on. Hopefully you've already established your relationship with an attorney. Great opportunity to message them and say, hey, I received X, Y, and Z from this entity or agency. advice, please, and go from there. That's really the responsible thing to do. But you really need to make sure everybody in your organization that has a voice to speak for the organization or has agency to do things on behalf of the organization is informed on what your organization's policy and procedures are. And you really should spell those policy and procedures out. I think it would be very helpful to not have anything ambiguous, and make sure everyone's of the same mindset, that there's a clear meeting of the minds. Um, and make sure that you're centralizing your communications through perhaps one person. That might be some good advice. That can communicate with the attorney, that can also communicate with the public if necessary. Um, I think if you really focus on like these are the proactive steps that we can take, then you can sleep better. And I also, before I leave you all to Jared, I want to leave you with that. That even if right now you're listening, you're like, oh my God, I've not done any of these, I've not done all of these. I'm a little like that anxiety to not dig into like what we've missed out on because you think it might expose you. No, like now is the time to start. Start documenting if you've not already done so. Start taking good minutes if you've not already done so. And also, I think it's a good question for you to ask your attorney. What can you do about the things that you haven't done or that you've already done that may not be in alignment to correct them and make sure that you're not doing it in a way that you're like structuring evidence or prospective evidence or things like make sure you stay in compliance. Get legal advice. Like, what can you do to fix what you didn't do? How can you make sure that you are in compliance now and shield yourself from anything that you may have not done? Like, it's totally, I'm telling you, this is not abnormal. So if you're feeling that pit of, ooh, we could have done better, good, do better now. So with that, thank you all so much for what you do. And I love this state and I love its people and I really love what you all do. And so I'm going to leave you to Jared. Thank you.
Thanks, John. Go ahead, Jared.
Thanks, John. So I wanted to just continue the conversation around these actionable defenses or action items that we can actually do with respect to mitigating our risks. Lawyers love to talk about risk mitigation, and how we can avoid exposing ourselves to unnecessary risk. And one of the areas, and this is perhaps most relevant here because you are thinking about advocacy, and how to be change makers, right? The point of advocacy is to make change in some way, right? So I think one of the things that is worth having a basic understanding of, and I will just say, I'm just going to sort of gloss over at the 20,000 foot level, and you can dig a lot deeper, and I'm sure we can get you resources if this is something you're interested in. But what are the rules? And I think there's a lot of misinformation and rumors out there around nonprofits or 501c3s engaging in advocacy. I'm sure you've all have some basic understanding that there is some limits to what we can and can't do as nonprofits. And so I wanted to talk a little bit about some of those, with respect particularly to political campaigns, electioneering, advocacy, and those sorts of things to sort of give you a high level overview of the do's and don'ts, right? The big pitfalls. Again, this is a very intricate area of law, so I don't want to represent that all this is an all-encompassing, few minute presentation. You certainly could dig deeper and speak to counsel about it if you're an organization that's engaging in advocacy in some way. But this will at least hopefully give you the basic framework so you know what questions to ask and what things to be thinking about, right? And I think it all boils down to, right, the upshot, right? Nonprofit arts organizations, but quite frankly, all nonprofits. Vermont Law School, is a nonprofit, and we have to be mindful of how the limits on our ability to engage in political action and political advocacy could impact our status as a 501c3 nonprofit, right? Which is a privilege and a benefit, right? There's no First Amendment right to be a nonprofit, right? There are rules you have to comply with. And so I wanted to highlight some of those. So there's something called the Johnson Amendment, which really is the broad term for this general prohibition on particular types of political advocacy that nonprofits might engage in. So the first one I want to highlight, and this is, I think, the one that's the most fraught for nonprofits, is electioneering. basically what we're talking about there in general terms is a nonprofit engaging in a partisan political campaign for or against a particular candidate, right? There's an election, there's a declared candidate, and you're the executive director of the nonprofit or the board of the nonprofit, and you want to support them because they are aligned with your views of the world. Um, right? A big no-no is do not engage in partisan campaign activities, right? And that doesn't matter if it's, a federal candidate for Congress, Senate, president, or if it's city council, right? All levels of candidates are off limits with respect to direct electioneering, right? So what does that mean practically? Well, first of all, an organization should really not be allowing a particular candidate to speak at an event that they're holding, right? Because that could be deemed to be supporting that candidate, um, unless they're only speaking about some mission-driven work of the organization. So, right, just because these rules are in place doesn't mean that we like all check our free speech rights at the door because we're a nonprofit, right? You could still invite a candidate to speak um, about the work the organization's doing, right? About the mission driven work. Again, to John's point about everything, tying it back to the particular mission, that would be okay. But what you don't want to do is appear to be a cheerleader for a particular candidate. So you just want to be mindful of that. And again, I think if you were an organization that's interested in hosting a particular candidate to talk about your organization, it's probably worth digging a little bit deeper into the nuances of this, maybe talking to counsel, reaching out to the clinic or other resources to sort of dig deeper. But I wanted to frame that one. And then the other thing to remember is uh, you hear this phrase like once a candidate, always a candidate. Right? If somebody's been a candidate once, you can never promote them again, even if they lose or don't run again. And while that's not technically accurate, the safe bet is to be very careful about anybody that's engaging in partisan politics as a candidate. Taking participating in an event in which they're going to get to speak and others aren't. Um, Again, technically, someone who's an incumbent and has not announced their candidacy is okay. Right. So like if you wanted to have the governor come speak at an event that you're hosting, before the governors declared their candidacy and they're an incumbent, you're probably going to be okay. But you need to be careful because these aren't entirely settled areas of law. And so inviting, any political leader, even if they are already elected, you want to make sure that what they're saying is really going to be tied to the work that the organization's doing, as opposed to like an opportunity for them to give a stump speech. And it's okay to tell them that, right? I mean, hopefully they understand and respect the what you're saying, and if they don't, well, maybe they shouldn't be there anyway. Um, all right. All right. So that's electioneering and partisan politics. What about lobbying and legislative activities? This one is also a bit more nuanced. The bottom line is nonprofits are allowed to engage in advocacy and even lobbying. But you need to be mindful of how much you're doing it. And you want to keep careful records. And by the way, I'm only talking about sort of 501c3 status requirements, right? There are state level lobbying rules and disclosure rules that anybody that engages in lobbying has to make sure that they're complying with. I'm not focused there. I'm focusing on the specifics that are relevant to one's 501c3 tax exempt status with the IRS. So you are allowed to engage in advocacy and even lobbying, but first of all, you need to keep very careful records, right? Who's doing it? What are they lobbying on? When did they do it? How much time did they spend on it? Did you spend money on it? Because the rule says, the IRS rules and the regulations say that lobbying is permitted for nonprofits as long as the organization does not spend more than an insubstantial amount of energy, finances, or other resources toward lobbying activities. Which basically means you can kind of dabble in it, but if the nonprofit sort of crosses this threshold and is now spending significant amounts of its budget on lobbying, then you're probably going to be running afoul of that 501c3 requirement. So you just want to be mindful, keep careful records so that if you were asked, you could document the fact that, you only spent half of 1% of your budget on lobbying, right? That's why those records are important. And lobbying is really any communications with legislators about legislation in which you're urging them to vote for or against it. So you can talk to legislators and educate them about what your organization does. Like that doesn't count as lobbying. Lobbying is when you enter into that world of saying support this or oppose that. Support SB 146. I have no idea what that is, or if that's even a thing. But you get the point, right? You cross that line because you're opposing or supporting a particular piece of legislation. So that's lobbying and legislative advocacy writ large, or legislative activities. Um, the last piece that the Johnson Amendment sort of impacts, and I think is often relevant for nonprofits, and I think can sometimes be confusing. Say, well, I'm not allowed to do partisan politics. I've got to be careful about my lobbying activity. Like, what the heck can I do? Um, the answer is nonprofit organizations, nonprofit arts organizations, but all nonprofit organizations that have that 501c3 status can 100% engage in voter and civic engagement. Right? You can educate the public about what you do and why it's important and the impact you have, right? Even in the policy context. That's, I think, fundamental to what organizations often do. But education is really the key, right? You cross that line into lobbying or partisan electioneering when you start saying, you don't just say, hey, let me educate you about the importance of arts in our town, but you say, let me educate you about the importance of arts in our town, and this is why you should support SB 146, which Nicole told me isn't a real thing. Yeah, right. So I think education is key. As long as you're just educating, right, that's 100% fine, and you're not going to get in trouble for that. And it can even be about the issues that you're advocating for. And in fact, it should be, right? It's that mission center. Nonprofits may hold, in fact, Vermont Law School does them fairly regularly. Even though you can't engage in partisan politics, if you want to hold a candidate forum to do, sort of a candidate debate or whatever you want to call it about the arts, your organization can do that. But the key there is you want to make sure you're inviting all the candidates. I think, in my view, all candidates that are on the ballot. Some organizations take a slightly different view of that in terms of who gets invited to the events. But I think the best rule of thumb is anybody that's on the ballot, invite them. You can have a candidate forum, ask them tough questions about whatever it is that your organization's mission is. 100% fine. You're not going to get into trouble with that. Okay, and I think that sort of wraps up the mitigation strategies. And I think I'll turn it back over to Nicole to sort of wrap us up, and then I think we'll have some time for Q&A.
Yeah, actually, I'm going to hand it to John, who's going to wrap us up for this part. And then I think you're going to hit the final point, Jared.
So just to kind of put a capstone on everything for you, I think what you should take away from today's conversation is that there are issues in as far as the way things are being administrated from the top down right now. Really, a lot of ambiguity, a lot of lack of clarity, a lack of guidance from the top down from some agencies, and that you just really need to worry about the scope of the work that you are doing. From a governance standpoint, what this really means is that sound organizational governance and taking proactive steps to build relationships with people who can advise you and who can help you is really going to be important for you. I would not want to be personally in a situation where I was caught unprepared for anything without having thought of what resources there are for me. Just like at home, you want to have a fire escape plan from your house if you've never created one. That's very advisable. Like, where is your family going to go? Where are they going to meet? What should you grab? Is there like 5 pets that you have that like people need to be responsible? Like, have you unpacked these things? Your organization needs to have an action plan that is, in a way discussed and rehearsed so that you know what to do and stay calm in a stressful situation. Preparation is key here, but also crossing your T's and dotting your I's, and a lawyer will help you do that. And so just, I know this can all be very overwhelming, but take the opportunity. And obviously there's a Q&A after this, but take the opportunity to kind of assess like what have we not done? Do I actually know that we are in full compliance, or do I just think it, right? Be objective. So final point I'm going to leave open for Nicole or Jared.
Go
Yeah,
ahead, Jared.
yeah, okay, sure. Yeah, I think where I just want to leave folks, and I think we've got one more slide here, which is thank you, but where I want to leave folks really, I hope, with some sense of optimism, and trust. I mean, Nicole and John and I spend, our lives learning and studying and researching and talking and doing this in the legal space. And so while I 100% get that, why so many people at the very beginning raise their hand and say, we feel kind of scared, we feel consternation, we feel concerned about the landscape we're in. Um, I believe, and I mean this genuinely, that the rule of law is alive and well. That the courts are acting as a check where they need to. That the democratic process, small d democratic process, will play out, and that advocates, artists, political advocates, community organizers, in whatever issue it is that fires you up, and lawyers, by the way, will be a bulwark in this journey. And so even if it feels overwhelming, I think there's resources here. We want to be a part of that. But the bottom line, I think, should be, and if you went back and counted my slides, there were more good news slides than bad news slides. Then I think we're going to be in an all right place. And I think there's even opportunity for creativity, and energy and action, even in a world that maybe doesn't feel like it's supporting us the way that we want to be right now.
Yeah. Thanks, Jared. I'm not going to say anything else. I'm just going to say thanks for joining us.
And we'd
So
certainly
we
love
would be happy to
questions.
take questions. Yes, please. I don't see any in the chat, but if there's anything, Desmond, or I don't know if you've heard directly from anyone, or we'll take Q&A as well if anyone wants to jump on.
Yeah, I haven't heard any questions from the chat either, so folks can put them in the chat or just raise their hands. We can call on people.
Go
I
ahead,
see
Catherine.
Catherine.
Sorry, you can call on the Desmond. I'll let you do
Oh,
that.
you can go ahead and do that. I actually
Okay.
Hi, I'm Catherine Clark from the Youth Opera Company. One of the things we started doing was using AI to keep our minutes. So what do you think about that?
What do we think about using AI to keep minutes? I would say, so for my own purposes, for our own meetings, if we have confidential information being exchanged, we specifically do not allow AI. And one concern, harken back to the suggestions that John gave, which was that for anyone who's keeping minutes, they want to keep the minutes and the details of those minutes restrained and condensed to just the items that need to be contained in those minutes. So one of the things about AI is that it gathers everything and gathers the conversation and the positions and maybe some opinions that people have offered. I would be cautious about using AI to summarize minutes and perhaps use that as a starting point, just as with everything else, and then go through and edit out and make sure, as John said, that the minutes being captured relate to the issues being considered and that they all tie back to the business of the organization and the mission. Do you want to add anything, John or Jared?
Yeah, I mean, I would just echo what you said. I mean, AI by definition is listening. And so I think while it certainly can be a helpful shortcut, and I get that a lot of times it's hard to, find someone to take meeting notes and those sorts of things. I think it's ill-advised, for that reason, alone. And I don't think this isn't like conspiratorial. I think that's what it does. And so certainly any confidential information, that could be problematic. And then, just in terms of what it produces. I mean, a lot of times, as good as it's gotten, and I mean, we use it in the legal profession, it's still, coming up with things that are incorrect, inaccurate. And so I think, that while it can save time in some places, that wouldn't be the place I would use it.
I also want to add on to that. I think, and this is not just for you, Catherine, but for everyone. your minutes, as far as I'm aware, there is no requisite they have to be 2 pages or 3 pages or like a litany of task. If it's brief and concise and short, that's really to your benefit. It makes your minute taking duty super easy. Just there are very specific things that need to be included. Find out what those are and only include them. Again, like date, time, who's present, matter before us. What did we do? Answer those questions. Boom. Who called closing to the meeting? Like, make sure you're just in adherence to the procedures, and that's what you're putting in the minutes, and you're golden. And it's just a record. Did we comply with our bylaws? Did we comply with the rules that guide what our bylaws are from, for instance, the IRS in order to maintain our nonprofit status or charitable status or whatever type of nonprofit you're registered as? So that's the
Does
last
that
thing I've
make
got.
sense, Catherine? Thank you, John.
Thank you. It's very helpful.
Other questions? Sage, you have a question. I see somebody else too. You want to go ahead, Sage?
Sure. Should an organization go back and clean up its minutes from the past if they're problematic or could be problematic?
Yeah, I mean, I don't think there's any problem with going back and making edits as long as you're doing the things that John talked about. Um, because there isn't a specific requirement of like what has to be in it. So to my mind, that wouldn't be problematic as sort of housekeeping. But
Was
you
there
of course
another?
want to do I mean, again, like to the extent that there's some process by which minutes are adopted, internal governance. I think you
Right.
want to make sure that you're complying with whatever the internal governance of the organization are. Um, but
Jared, I had one question for you actually from an earlier discussion regarding the non-politicking. Genuinely curious, your opinion on what if, for instance, like what if I were a town clerk and I also want to be involved in a nonprofit. Maybe I'm on the board and because you use the word like nonpartisan, I want to know like what constitutes partisan, like an objective like nonpartisan town clerk, is that kind of being overly analytical of
yeah,
what nonpartisan is?
I think it's always good to be cautious. What the where the issue is going to come up is not so much in um, can you be on a board and also involved in politics, as long as you very clearly separate and delineate those things, and make clear when you're speaking, in one role versus the other. Um, uh, but more the idea of supporting a political candidate when it comes to politicking and electioneering. So let's say you were running for an office, and we're also, part of a nonprofit, and we're getting to speak at that nonprofit about stuff other than what the nonprofit does, right? About your campaign or your views on particular issues. That would be a big problem, right? But we don't check our fundamental First Amendment rights at the door just because we go into government service or because we participate in a nonprofit organization. It's just delineating those things is very, very important if you occupy two spaces. And a lot of times, people that are serve on boards or associated with nonprofits are also involved in community things along those lines. So it's not a rare occurrence, but it's very important to delineate and segregate those two things out.
Even judges have the opportunity to participate in civic organizations and in nonprofit organizations. They usually have to be related to the law or judicial reform or something like that. But even judges who have to have the total appearance of being totally nonpartisan, and that would be an improper thing to imply that a judge has an opinion about something, they are also allowed to participate. So to the extent that there's concern with partisan politics, as Jared has said, it's a matter of the organization as a whole and how its message is being portrayed publicly, and that has to do with the activities of the organization, whether they align with the tax-exempt purpose that the organization got in the first place. How those things tie together is going to determine the public view and is going to determine a lot of the other things. The mission and the focus of a nonprofit organization really has to be the guiding light for everything, and that provides also safe boundaries for the nonprofit if they stay within those.
Yeah, and I just would add, this is I think just to piggyback on what Nicole was saying, and I think maybe responsive to the question as well. One of the things that nonprofit leaders want to be aware of is, again, while we don't lose our First Amendment rights to speak on matters of public concern just because we're, the chair of a board or an executive director of a nonprofit, is if you are in a leadership position, it's always better if you're speaking publicly about a particular candidate, to make sure you lead with, I'm speaking on behalf of myself as a citizen or a resident,
Exactly.
of my community, and not as a leader of the organization, because sometimes it can be blurry. Are you speaking on behalf of the organization, or are you speaking on behalf of yourself? And so for folks in leadership positions, I think the best advice is always to, sort of have that disclaimer at the outset, and then you can never be accused of violating that sort of electioneering rule.
Yeah. These are great questions. We've only had 2 of them, though. Any others? Well, if we don't have any other questions, we can wrap it up, folks. This is recorded, right? So there will be a second life if anybody wants to watch it online. Hopefully we can capture some more folks. We are happy to answer any of these questions. We would be thrilled to talk to any of you. If you want to visit us at Vermont Small Business Law Center, I'll put it in the chat. Do educational conversations about all of these topics and more. And we are also able to, as I said, get you to an attorney if you feel like you're ready to, or you feel like you want to shore yourself up with that. So let us know how we can help. And thanks for joining. Did you have anything you wanted to wrap up with, Desmond, or anybody else?
Just like to thank you all again for sharing your expertise with us. This has been a great webinar, and thank you everyone for joining us today. And also, don't forget, we have 2 more advocacy events coming up this fall. I'm going to put the link for those again in the chat. Have a great day, everyone.
Okay, great. Thanks, guys. Have a good day.
Bye-bye. Thanks, everyone.